I'm Angela Scappatura from Canadian HR Reporter TV. Today's guest is Ian Turnbull. He's the Executive Director of the Canadian Privacy Institute, and he's here to speak with us about privacy in the workplace.
So how should employers approach privacy in the workplace?
Well, there are really two different things. There's privacy law around employees and workers. Let's call them workers. And there's privacy law about other information. So, for example, employers should be concerned about the privacy and security of their own corporate data, their financials, for example. On the worker side of things, there's a difference between employees and contractors and consultants and so on. They are all individual people. They all have personal data, and that personal data all has to be dealt with. But in Ontario, for example, if you are an employee, you have no expectation of privacy rights because Ontario doesn't have a law. On the other hand, if you are a contractor or a consultant, you do have an expectation of privacy because you are not an employee. You are in a commercial relationship, and that commercial relationship is governed by the federal law. So you know, these kinds of distinctions occur across the country. So if you're a typical employer who's operating in 6, 8, 10 provinces, you're going to have to deal with slightly different situations. And you have to be aware that, again, it's employees versus workers who are not employees. And then it's other people as well. So, for example, if you deal with customers, they are people who have personal expectation data concerns. And those would be covered, in Ontario, those would be covered federally. So if you're a retailer and you have information about what size clothes people are buying, that's considered personal information, and it's covered by the federal law. On the other hand, your employees who are selling that clothing, because they're employees in the province of Ontario, you don't have to legally be responsible for their data. But if you're running stores across the country, you do have to be responsible for the data that's in Quebec, in Alberta, and BC. And probably what you should be doing is establishing one overriding approach to how you're going to handle the privacy and security of all data, and in particular personal data.
What are some of the common mistakes employers make when dealing with privacy?
Well, the first thing is that you know, again, let's look at the example of financial data. Financial data is the company's. The company owns it. Personal data is not owned by the company. Personal data is owned by the person about whom the data is. A terrible sentence, but you get the idea. So an employer is only a custodian. We typically think of the information we have about you in a personnel file is considered to be our personnel file. But in reality, that data is your data, and we are custodians of it. So we have to recognize that you have a right to know what data we're collecting, why we're collecting it, and that we're being responsible with regards to its security, its timely destruction if it's no longer required, issues of that nature.
So for employers thinking about developing their own privacy policy, what are some of the elements they should consider?
Again, under the federal law, if you have any personal information that is subject to the federal law, you are required to have a privacy policy. If you are only dealing with employees and only in a province that doesn't have a law, like Ontario, then you are not required to have one for that. But you may be required under the federal law because you have customers, wholesalers, and other workers. So we recommend that you put together one privacy policy, one set of procedures, and that you're consistent right across all the various types of people for whom you have personal data. That's the easiest way. You make sure you're compliant with the federal law, the provinces that have legislation, the provinces that may get legislation. So, I mean, Ontario could get legislation, then you've already got something in place. So that's the best way of approaching it. People have the right to know that you are collecting data about them. People have a right to know what you're using it for. People are supposed to be giving consent for that. Now, I'm sure you've been on a phone call where the message at the other end is, we're going to record this call for training and audit purposes. You have to give your consent to that. And by staying on the line, you are giving your consent. Although you could say when the person comes on, I do not want this recorded because I don't want my personal information recorded in this way. And theoretically, that vendor, whoever they happen to be, should respect your rights and not record that information. Similarly, if they don't need it anymore, they should be getting rid of it. So there's the whole destruction side of personal information as well. Once an employee has left your employ, how long do you need to keep the information? Well, under Employment Standards Acts and various other acts, you may be required to keep the information for 3, 5, or 7 years, but at some point you no longer need all of that information for your legislative requirements, and you should be destroying that.